Okay, this is part two. We were part two of chapter 8. We were talking about a right to counsel. So I finished off part one talking about if you have retained counsel or you hire an attorney, then you simply can fire them with some restrictions. So I've seen defendants kind of use this process as a way to stall um, their court hearings. So they'll hire an attorney and then they'll let the case drag out for a while, then they'll fire that one and then hire another one. And at some point, the court will simply say, no, enough is enough, and they will not allow you to fire your attorney and they'll move the case forward. So, what happens if your attorney is appointed? Then there are certain challenges. So when we talk about ineffective assistance of counsel, we're talking about their inability to represent you. But this is a challenge to evaluate the quality of work of a defense attorney because um, a defense a defense attorney or a prosecutor in a criminal or a civil case, think of it as a chess match, and every player plays the game a little differently. So you have some defense attorneys that um, will call in lots of witnesses. They will object to everything. So when you go to trial with them, any opportunity they have to object, they will object. Even over the most basic questions that we all know as attorneys are valid questions and the court's going to allow those questions to come in, they still object. And usually these are newer attorneys. Newer attorneys feel that they only can do their job if they're objecting to everything. And there's a real difference in working with new attorneys and working with seasoned attorneys. Seasoned attorneys, they are what I call energy efficient. They are going to know exactly where they need to fight, and they know exactly where they need to raise attention to the jury, and that's when you're going to see them stand up and do their job. The other stuff, they're not going to even, they're going to let things in that they could technically object to. The best attorney I ever worked against, just a brilliant lawyer, he would walk in and say, look, let's do the hearing. I'm not going to object to A, B, C, and D. Let's just get those things on the record because here's where I'm going to attack. And he would tell you exactly what he was going to do, and then he would beat you up. I mean, you'd walk out of that room feeling like you had just gone through, somebody had shoved you in a dryer and turned it on for 2 hours. I mean, he was so good, but he didn't waste his time. If it was a drug case and you needed to introduce the drugs, he would say, "Look, we'll stipulate it's cocaine. You don't have to bring in the expert to say that they tested it and that it's cocaine. We'll all just agree it's cocaine. I don't care." New attorneys, they're going to want to bring in the expert. They're going to object to the expert. You're going to ask the expert their name. They're going to object to the fact that you're asking the expert their name. Sometimes it gets a little silly, but it's all strategy. So it's not it's not the fact that a defense attorney did not ask a particular question. In fact, sometimes I've seen a defense attorney go through an entire trial and not ask any questions. And it was a great strategy because the prosecutor just didn't have the enough evidence, and the prosecutor's witnesses were very bad. Not any fault of the prosecutor; it's just that's the hand that this person was dealt. And so the defense attorney just sat back and said nothing, did nothing, let the prosecutor put on their case, and then at the end argued that this was not enough, and he won, or she won. Excuse me, it was a she. She won. So it's not that they're not asking questions. What the court looks at is that the defense attorney is taking an active role, meaning that they're aware that when there are times when you absolutely must make an objection, and that's when you'll see them stand up and make an objection. There are many times that it's a strategy whether you want to object to something or whether you want to present something, and they will know when to do that. So, for instance, if the defendant says, my brother Tommy was there with us that day, he's a good witness for me, and then the defense attorney talks to the brother, and the brother is a drug addict, just got out of prison, has a long criminal history, and physically just doesn't look like somebody you'd want to be around. The defense attorney may say, I'm not putting this person on the stand. I don't want the jury to know you associate with this person. So again, that's a strategy. And it's not because it's a bad defense attorney. It's actually a good defense attorney that they're taking an interest in their client and trying to protect their client from doing something foolish. So the court applies this minimum standard. It says you have to be actively involved. And judges are trial attorneys. Many of them are themselves. They understand what that means to be actively involved. And so they are the ones that are going to make that judgment. All right. And then the last line here is that right here it says that there's a distinction between retained attorney and appointed counsel. So if the court finds that the performance is inadequate, that the representation was so poor that the counsel ceased to play an active role. So we had an attorney that had a methamphetamine addiction. He fell asleep during trial, and so the court found ineffective assistance of counsel. And the court had to go on the record, and this was very sad, that you had a very, very good defense attorney who just had made some poor choices, and one of them was using methamphetamine. And so his addiction had gotten to the point where he was not able to function anymore as a lawyer. And so during trial, he fell asleep. And the court deemed that to be ineffective assistance of counsel. And he was reported to the state bar. He lost his license for a period of time. And the defendant was appointed a new lawyer. So the court looks at, if the representation has to be so poor as to no longer play an active role, and that the performance is just inadequate. So these are, again, judgment calls. They're very difficult. Judges are slow to make these decisions because they understand that a lot of what goes into a lot of the decisions an attorney will make is based on their knowledge of the entire case. And the court does not have knowledge of their entire case. And so these decisions are very difficult, and a judge is going to be very slow to find somebody performing at an inadequate level. So the standard has it's a two-pronged test. Court has to first find that, let's assume that they find that there's ineffective assistance of counsel. They have to find that assistance did in fact prejudice the defendant, and that there's a reasonable possibility that the outcome would have been different. So it's not just that they made a mistake. Attorneys make mistakes all the time, whether you're a prosecutor, whether you're a defense attorney, especially in criminal cases where information is constantly coming in, things are constantly changing, people are constantly changing their statements. Attorneys can make mistakes. It's that one, you made a mistake, a grave mistake, and two, that mistake is so serious that there's a possibility that the outcome would have been different. So oftentimes the court will say, yes, the attorney made a mistake, and then they'll say, but you know what, the evidence against the defendant was so overwhelming, we're going to leave the verdict. All right, so appointed counsel, the defendant has a right to appointed counsel. You don't get to pick your attorney. The court picks the law firm that will represent you, and the law firm will pick your attorney. So for the public defender's office, since they have so many cases, they function a little differently than a private office. So at the public defender's office, you get one attorney at the beginning when you first get arrested. You get a second attorney oftentimes when you go to all the pretrial hearings. And then if your case gets to trial, if that pretrial attorney cannot settle your case, and your case goes to trial, you get a third attorney, and that attorney is his or her specific job is to do the trial. It's a very efficient way for them to function. Public defenders, let me just say right up front, public defenders are attorneys. They do a great job. The majority of public defenders, just like the majority of prosecutors, are very competent, and they work very hard in doing their job. And so public defenders, the benefit of a public defender is they're in court every day. They know the judges. They know what the judges like. They know what the judges don't like. And so they can move very efficiently and productively through the court system, and they can protect an individual's rights and not make those silly mistakes that sometimes private attorneys can make if they don't know the court very well. All right, so you have a right to competent counsel. You don't have a right to pick your attorney, but you do have a right to competent counsel. If your attorney is appointed and you think that your attorney is not doing a good job, then you could raise that issue to the court, and then the court would have a hearing, and it's called the Marsden motion. You don't have to know what the name is specifically, but they just have to tell the court judge, my attorney's not doing his or her job. And what the court will do is they will have a closed hearing. They usually remove the prosecutor. And then they'll ask the defense attorney, tell me what your strategy is. Tell me what you've done for your clients. So sometimes the the defendant will say, he's not calling my witnesses. Court will look at the defense attorney and say, why aren't you calling these witnesses? And then the defense attorney will say, I had an investigator talk to this person. This person has a methamphetamine addiction. This person just got out of prison. These are the reasons why I'm not calling this person. Or this person participated in the crime with the defendant, and he would have to take the fifth, and I can't put somebody on the stand and expose them to criminal charges. It's not going to benefit my client to put this person on the stand. So the judge will listen to both sides, listen to why the defendant says that this attorney's not doing their job, listen to the attorney and to their strategy and find out, what they're doing, and then make a decision. Judges are very slow to find that the attorney is ineffective. Sometimes what the court will do is, in discussions with the defendant and the defense attorney, realize, okay, this relationship's not working. These personalities will not get along. It's not going to be productive for the defendant. So the court will relieve the attorney, not finding that they are competent, but that these two personalities are not able to work together, and then the court will appoint another attorney. But they'll make a very clear point on the record that they're not being removed for ineffective assistance of counsel. So you'll see that happen once in a while. So the defendant has a right to have counsel present for accusatory contact with law enforcement, meaning they have a right to an attorney at lineups. They have to request an attorney. The law enforcement does not have to give them any kind of admonishment. They have no right to an attorney to show up. So if the person's detained and you bring the victim to the individual that's detained somewhere out in the public, there's no right to an attorney. There's no right to an attorney for photo lineups, and you have a right to counsel at any interrogation. If you're being interrogated by law enforcement, out of custody, in custody, you always have a right if you want to bring your lawyer. It's only if you're in custody that the law officers have to give you that admonishment, the Miranda rights. All right, so lineups, and photo lineups and live lineups, they have to be, the evidence has to be competent and has to be reliable. So they have to, the people that they pick, for instance, on photo lineups, they have to be very similar. So if you have a white male with a balding white male, then all of the other photographs, usually it's a total of 6, all the six photographs should all be white or similar in color, and they should all have similar hairstyles. So you're not going to pick a black man with an afro if the suspect is a white balding male. And so you want your photos to match as closely as possible. With the computer programs that we have today, it makes it much more feasible for them to pick the correct set of photographs. All right. So again, go to assignments, submit a written outline in bullet point form for credit. And just a reminder that your briefs are also due this week. So the briefs for 7, for 8, and for 9 are due at the time during the same week. Be safe, and we're almost through this semester. So take care.